This is Law Bytes, a podcast with Michael Geist.
Canadians could soon have the right to be forgotten. It's a matter being considered by the Federal Court of Canada this year at the request of the Privacy Commissioner. The right to be forgotten would allow people to request search engines remove old or potentially embarrassing links about them.
Several years ago, the Privacy Commissioner of Canada filed a reference with the federal court in a case that was billed as settling the right to be forgotten privacy issue. That may have overstated matters, but the case did address a far more basic question. In the words of the reference, quote, does Google, in the operation of its search engine service, collect, use, or disclose personal information in the course of commercial activities within the meaning of paragraph 4.1a of PIPEDA, when it indexes web pages and presents search results in response to searches of an individual's name? Earlier this month, the federal court released its decision, concluding that it does. Mark Phillips is a Montreal-based lawyer practicing primarily in the areas of privacy, access to information, civil litigation, and administrative law in both Quebec and Ontario. His client, whose identity remains confidential under order of the court, filed the complaint that ultimately led to the federal court decision. He joins me on the podcast to talk about the case, where the right to be forgotten stands under Canadian law, and what might come next. Mark, thanks so much for joining me on the podcast.
It's my pleasure, Michael.
Yeah, it's a pleasure to have you. You know, you found yourself at the center of a leading Canadian case on the right to be forgotten and its potential application under Canadian law. Now, before we get to the specifics of that case and what the court had to say, why don't we start a little bit with the basics for those that are unfamiliar with the right to be forgotten? Can you walk through a little bit the principle and how it's developed, particularly, of course, coming out of Europe?
So the standard answer you'll hear to that question is basically that the European Court of Justice invented the right to be forgotten in a 2014 case called Google Spain, and basically its scope has been incrementally clarified since, which is not completely wrong, but there was actually a lively period of civil society mobilizing to grapple with the issue starting back around 2007. So for about the 7 years preceding the case. That gave rise to Google Spain, especially in Spain and France, but also to some extent in other countries like Italy and Germany. The organizing included groups like children's rights organizations, Innocence Project type organizations, and others who understood that their constituencies could suffer injustice if certain prejudicial personal information were to follow them around online permanently. The national data protection authorities, which are a bit analogous to the Office of the Privacy Commissioner here, were engaged in that discussion. And one might even be surprised to hear that industry juggernauts like Microsoft, Facebook, and even Google joined these other organizations at the table to draft a French charter of the right to be forgotten. Although when the final version of that document came out in 2010, Google and Facebook ultimately refused to sign it. So it was that kind of precursor activity that led to the Google Spain case in 2014, which was a watershed moment. The European Court of Justice was called on in that case to clarify basically how longstanding data protection rights would apply or could apply to Google search engine. So out of those existing legal rights, so for example, there's a right to rectification, the right to withdraw consent to the processing of one's personal data, similar things actually to what we see in some of the Canadian statutes. The court held that Google's search engine was subject to the data protection law, and that individuals have a right to request, and at least in some cases, to have specific search engine results not appear for searches of the person's name. In the aftermath of the Google Spain decision, there was even more lively debate about its result that really continued to cut across the standard battle lines that at least I'm usually used to seeing in privacy debates. So normally I expect to see often consumer and privacy advocates on one side and advocates of greater basically profitability for businesses on the other. But in the first years after Google Spain, I think we saw more strange bedfellows. And my personal feeling at the time is that many advocates who are rightly vigilant about threats to free and open internet were misled into misclassifying the Google Spain case as being among those threats. And I think superficially, it might look like it might replicate some of the types of problems that we could see in other areas, for example, like with the Digital Millennium Copyright Act in the United States, or the problematic Ecostec decision of the Supreme Court of Canada, that both of which I think you've talked about in your podcast before. But we've been living with the legacy of Google Spain now for 7 years. And as contemporary privacy issues become better understood, I think a lot of these people have come around to seeing that it's the real life adverse impacts on the accessibility of information is very marginal, particularly when weighed against the devastating impact for many people of having their most sensitive information accessible within a few keystrokes to anyone in their life. So a few of the concerns I actually think were potentially introduced by industry, either to promote their interest or for whatever reasons. So one thing that we commonly heard, and in fact are still hearing, an article in La Presse that came out just after the recent federal court decision repeated it again, is that a shortcoming of the Google Spain remedy is that it allows web pages to be de-indexed from Google, so there's no longer any way to find the web page through a search engine anymore at all. And I feel it's important to specify that that's not true, because it's a really common misconception. So the way it works, as I mentioned before, maybe quickly, is that when the remedy is granted, which it isn't always, it's essentially only for searches of a person's name that the specified URLs will no longer appear in the search results, and they continue to appear for all kinds of other search terms that might bring up the same documents. So they're not disappeared kind of in that way that one might have the fear of. And in fact, that more heavy-handed way is the way it worked, and delisting worked in cases like Ecostec that were outside of the privacy context. Another concern that was raised at the time was that politicians or public figures would be able to use Google Spain to sanitize or cover up their histories of misdeeds, or even keep committing them. But I think it's important to remember that the right to be forgotten, or if we want to call it that, isn't an automatic right. So you can make a delisting request, but then it's held up against multiple legal criteria. And the first criterion in Europe that you'll find, it more or less says that if you're a public figure, you don't get the right to delisting. And this has been quite effective at ensuring this concern doesn't materialize. And kind of the last thing I think I want to say about this is that there's also a lot of currency, I think, around that time, back around 2014, around this notion that once a piece of personal information is publicly accessible, say online, that's kind of it. You have no control over it, and it's at best foolish, and maybe at worst harmful, to even pretend you can impose any restrictions on the use and further dissemination of it. I think until pretty recently, a lot of people took this for granted, and it was a real part of the early criticism of the Google Spain case. But I think there's finally starting to be an understanding of just how threadbare that notion is, at least when it's applied categorically, especially through a number of controversies since then that I think you've analyzed, whether it's Clearview AI or whether it's Cambridge Analytica. That has really, these situations have really given people pause to say, maybe we don't want to live in a world where the rules are that every piece of personal information that's accessible online can be used for any purpose in any way without restriction. So I think I've deviated a bit, but to get back from your initial question, although there's been a number of refinements and clarifications to Google Spain in Europe, and there's been discussions about it around the world, I imagine a number of people at the time would be surprised that a number of people who had been concerned about it back in 2014 would be surprised at kind of how stable and non-controversial it quickly became.
Okay, that's a really interesting and comprehensive look at how it's unfolded in Europe as a principle and what we've seen over the last number of years. I think it's important to emphasize as well, and in addition to some of the limitations from a search perspective, that we're dealing specifically, of course, in the context of de-indexing, removal of the index from a search index, not removal of the content from the web itself. And then also, of course, the fact that this is lawful content. I mean, nobody says it's inaccurate. It's just causing some kind of harms. Is that correct?
I wouldn't disagree with maybe the statement, but I think the framing of this notion of lawful content is a bit unclear to me. I mean, we have some cases where, for example, say content is available behind a paywall, for example, for copyright reasons online. That I think is lawful content. It's not unlawful for it to be there, but it would be inappropriate probably for certain uses of it to be made by certain people. So there's a sense, yes, that there's no lawful in the sense that there's no no court order that exists that it should be, scrubbed from, the face of the earth. But I think that personally, I actually think the notion of lawful content isn't that helpful here. But I'm not sure if that answers kind of what you're getting at.
Okay, well, I mean, I guess I just wanted to emphasize that, where we're dealing with unlawful content, obviously we've had, we have courts that will sometimes call for the removal of that content, the original content. We've had governments, of course, increasingly focus on potential takedowns. Here we're talking about content that wouldn't be taken down per se, but there's certainly an attempt to try to make it a bit more obscure and more difficult to find, given that it's accurate but potentially harmful.
Exactly, and I think getting back to your kind of initial comment, that's an important point that I should have raised too. That the underlying web pages aren't deleted when this remedy is exercised either. I kind of focused on the fact that they're even still accessible on the search engine, but that's true. So yeah, there's no legal impediment to them continuing to be available in that sense.
Okay, that's good. No, I think it is definitely useful to establish sort of a common understanding or framework for thinking about some of these issues. So that was a really good look at what's taken place in Europe up until this case. What had taken place in Canada when it came to this issue?
So as far as directly addressing the issue, my sense is that it's basically uncharted, and even in this case, Associate Chief Justice Gagné was quite explicit in her reasons that the reference didn't analyze or weigh in on the delisting remedy that we're requesting at all, and the court was only resolving a couple of preliminary issues regarding whether Google's search engine is even within the scope of application of the relevant Canadian data protection law, which is PIPEDA, of course, the Personal Information Protection and Electronic Documents Act. Which is not to say that you can't find precedents in analogous situations in the case law if you look. And you'll even actually find the phrase right to be forgotten in a few old decisions, but it's not really being used in the internet context that we'd expect for the most part. But I think the one precedent that stands out more in this respect is an earlier federal court case called Globe24h.com or Globe24h from the start of 2017. I think it bears pretty directly. So if you think we have time for it, I'd love to go over what happened in that case, because it's also, I think, a fun one to look at.
Yeah, sure. Absolutely. No, it's a case I know well, given that I was sitting on the CanLII board in and around some of the same time that the case was taking place. Go ahead.
So it came out of an OPC complaint, or an Office of the Privacy Commissioner complaint against basically a guy in Romania who would use software to surreptitiously download most of the Canadian legal decisions, as I understand it, from, I just mentioned the popular free site CanLII. He was eventually detected by CanLII and blocked from getting the rest. He ended up republishing the decisions on his own website. Only on this site, unlike CanLII, he configured it so that Google would index all of those old decisions. So now suddenly when Canadians Googled their names or the name of someone they knew, they would discover that like the person's old divorce proceedings are coming up in the search results, or old criminal cases involving the person are coming up, and people were immediately unhappy. But it turns out that the website offered both the disease and the cure, right? It was happy to respond to privacy-related requests from Canadians to anonymize them. There was just a processing fee involved that you had to pay. So it's basically this extortion site based on personal information, although the site also generated revenue by hosting advertisements on the site. So eventually, when the case went before the federal court and an order was sought to take the site down, it raised, I think, a whole pile of novel legal issues related to PIPEDA, which again is the federal private sector data protection law. So first, the court had to ask, does PIPEDA have any legal force outside of Canada? Second, is the website exempt from PIPEDA because personal information is used exclusively for journalistic, artistic, or literary purposes? And third, is the website exempt because the personal information isn't being used or processed in the course of commercial activities? I'm sure the facts didn't make it any harder for the court to come to the conclusion that yes, PIPEDA could apply in Romania, and no, the website wasn't exempt, and the court ordered that the pages be taken down. So in a lot of ways, a lot of the legal issues were somewhat similar. So for example, Google, the defendant in this reference that I was involved in, are headquartered outside of Canada. So now that question was resolved. These other issues I just mentioned came up too, but it really wasn't explicitly a case about delisting, but there were striking similarities that a lot of people, including yourself at the time, Michael, noted.
Yeah, no, it's definitely a case that got a lot of attention, as I think will this case. And so why don't we shift gears to talk a bit about that case? Now, as you know, one of the ironies of these right to be forgotten cases is, of course, that the complainant risks being identified by bringing forward the case, the exact thing in some ways that they're trying to avoid. So, what can you tell us about the facts of the case, while, of course, also ensuring that your client isn't identified?
Yeah, so one of the things that I'm saddened about a bit is because I think on the level of being able to communicate, to the public and the profession, why this remedy is so important. The situation that my client's been facing for many years now really illustrates the need vividly. But the federal court did order a ban on disseminating any information that could identify my client for good reason. That's maybe obvious. And unfortunately, most of the facts that illustrate the client situation, I feel, could likely be combined with other facts to lead to identification. So I think there's only a few things I can say, but some of them I mean, and of course, I'm saying this without being able to have facts about it on the public record, so someone could always come along and disagree. But from my perspective, you'd be really hard pressed to argue that my client did anything wrong that could be said to make it the client's fault that they ended up with the Google search profile that they ended up having. But now that search profile does cast a very dark shadow over all aspects of the client's life. So including relationships with coworkers, friends. Anytime the client meets new people, the client's in fear about them discovering the search profile. There's at least in one case, the client was physically assaulted due to the assaulter having read the search engine results. It's also allowed prospective landlords, employers, or others to effectively sidestep the human rights law that's enforced by allowing them to effortlessly learn facts about the client that amount to prohibited grounds of discrimination under relevant human rights law that they don't have any business knowing. And then they can essentially surreptitiously use those facts to discriminate against the client in rental, hiring, and other decisions. So essentially, the really difficult situation the client's in the wake of the federal court's decision in Globe 24H, ended up leading me to file the complaint with the privacy commissioner on the client's behalf in June of 2017. And a little over a year later, the privacy commissioner decided to exercise this power it has under the Federal Courts Act. My understanding was that it was the first time in its history the OPC opted to use this power to refer two of the preliminary legal questions to the federal court in a reference proceeding.
Okay. So you've identified obviously what the kind of harms that existed using the complaints mechanism under PIPEDA to try to address them, and then leading, of course, to the complaint, and the commissioner, interestingly, moving towards using this reference as a mechanism to move the case forward or to better understand where Canadian law stands. Why don't we talk about both of the issues that were at stake or that were discussed as part of the reference? First one was whether or not Google's activities fall within the scope of commercial activities under PIPEDA. Google, of course, argued that it didn't, focusing specifically on the search results aspect of its operations. It wasn't saying that they don't do anything commercial. Obviously they do, but they were saying that the search engine results aspects of it kind of fell outside of there. How did the court work through that issue?
Yeah, so I referenced it before, but just to make sure it's clear why this is an issue at all, the provision in PIPEDA that sets out its material scope limits it to regulating processing of personal information in the course of commercial activities. So anything outside of the course of commercial activities wouldn't be covered. So basically, in responding to our complaint, Google latched onto that and said, hey, we're not even subject to PIPEDA because our search engine is not a commercial activity. So the OPC doesn't even have jurisdiction to examine this complaint. And when we ultimately made it before the federal court, the court didn't have too much trouble dismissing this argument, I don't think. So it noted that it focused on one of Google's main arguments as to why the search engine was ostensibly not engaged in commercial activity, which was that there was no evidence in the file, which we acknowledged, to show that any advertisement appeared on a results page for a search of my client's name specifically. So hence Google says there's no money being made and no commercial activity. I'm not sure if the court noted this specifically, but the reference question, I mean, they would have repeated the reference questions, which weren't specific to my client, were more broadly related to the search engine, especially in the context of searches of people's names as a whole. And so what the court really took note of was the fact that fairly well-known facts, I think, that Google's market dominance in search specifically has made it one of the most profitable corporations in the world. generating many billions in ad revenue in that process. The court noted that Google itself promotes its advertising business by highlighting the popularity of its search engine, as well as its ability to target ads to users based on personal information that's stockpiled about those users. So a minute ago, you mentioned that it's only looking at the search results, but in a sense, I read the decision as also being about this information on the searcher side, that information is being compiled about them too. And there's potentially questions about whether, PEPIDA is now more clearly applicable to those people too, whether they have the rights with respect to the search engine that wouldn't be related to a delisting request. But in any case, that's a bit off topic. So, or at least speculative. So to get back to the court's reasons, basically, the court held that just because some searches don't include ads clearly doesn't mean there's no commercial activity going on here. It can't be compartmentalized in that way. There was another argument Google put forward that basically no one pays anything to do a Google search. So then again, ostensibly, there's no commercial activity. And in that case, the court essentially noted that even if Google provides free services to the content providers and the user of the search engine, it still has a flagrant commercial interest in connecting these two players. That's a very close paraphrase. And then in concluding on this issue, Associate Chief Justice Gagné stated basically that the overall takeaway was that the different components of search shouldn't be looked at in isolation, and every component of Google's business model here is a commercial activity for the purpose of PEPIDA. And I also found it interesting that she notes here that Google has no commercial interest in delisting unless it's forced to do so. And this was the only point delisting is explicitly referenced in the decision, which jumped out at me a bit too.
Yeah, no, that is an interesting aspect. I mean, some of those questions, some of the similar kinds of questions came up, I think, a little bit in the Equistech case as well, where they talked about some of Google's motivations and the impact that these kinds of orders would actually have on the company. And of course, in that case, the Supreme Court wasn't particularly sympathetic to Google's arguments either. The second issue that gets raised, and so the issue on the commercial side, I don't think would take a lot of people by surprise. I mean, there's, obviously there is an argument to say that, there's an attempt to try to hive that off, but I think the court does look more holistically at Google's operations, recognizing some of the linkages that exist between its advertising business and its search business and the role that data plays really across those different services. The second issue, though, was Google's attempt to raise one of the exceptions that exist within PIPEDA, specifically the journalistic exception under the Act. How did the court go through that analysis?
Yeah, and so it's a different issue, but there were I thought a lot of similarities in the two. So again, the reason that we ended up talking about this is another specific provision in PEPIDA, which isn't about its material scope, but instead it's an exception that says that PEPIDA doesn't apply at all to organizations processing personal information for journalistic, artistic, or literary purposes and for no other purposes. And so again, Google tried to argue that its search engine was fundamentally journalistic or literary in nature. And so again, it's not subject to PEPIDA. And once again, the court rejected Google's argument and held again that Google was trying to put forward what it called a microscopic look at the situation, basically isolating a small part of the overall service. So to put that into a bit more of a practical example or analysis, Google pointed out to the fact that, again, that the specific web pages that my OPC complaint asked to have delisted were all news articles. But the reference asks about the operation of Google's search engine more broadly than with respect to just my client. And the court ended up noting that even looking at only its searches of people's names, the results will include many pages that are not going to be news articles. The court said this information is wide and varied. It's not limited to media content, and it can lead to a detailed portrait of an individual, which I thought was an appropriate kind of analysis of the situation. And then as far as whether Google's search engine itself has an exclusively journalistic purpose, the court applied the test that was previously set out in the Globe 24H case we were discussing a bit before. I won't go into all the steps. It's a 3-step test, unless you'd find it interesting. But essentially, I think the overall focus the court put in answering all those steps was to say that Google, unlike an individual journalist or even a media entity as a whole, doesn't have any control over the content of the documents that it's indexing. So it really drew a sharp distinction from there. And then finally, there was an argument from Google that it was an intermediary and a publisher and on that basis, it should be exempt basically from PEPIDA. And the court held that wasn't relevant because basically the wording of intermediary and publisher isn't included anywhere in the statute, isn't part of the analysis.
Yeah. So that's helpful. There were a couple of interveners in this case. One was CIPIC, Canadian Internet Policy and Public Interest Clinic, which I think largely aligned with some of the same kinds of arguments that you were making and that the OPC was making as well. The CBC was involved as well, specifically on this latter issue, on the journalism issue. What did they argue?
Yeah, so initially there was also a large media coalition, including essentially all of the biggest corporate players like the Globe, the Star, the National Post, et cetera, who had been seeking intervener status, although they ended up bowing out at an earlier stage, and so only CBC stayed around. And essentially the CBC's take on it was that where PEPIDA refers to journalistic purposes, and again, take this with a grain of salt, I'm kind of opposing counsel in a way to CBC here, so feel welcome to read their materials rather than listen to my take, but I'll try to give a fair take. So essentially, where PEPIDA refers to journalistic purposes, the CBC says this should be read as a more blanket exclusion against any application of PEPIDA to journalistic material, even if it's the hand of non-journalist third parties and wouldn't otherwise be seen as being used for journalistic purposes. And so CBC ended up also proposing a new test to supplant the one set out in Globe 24H that would, I think, basically reflect that position. And then they also raised some charter-free expression concerns in the course of the arguments too. And with respect to those positions, the court held that CBC and its proposed tests are essentially looking at whether news media have a journalistic purpose when they create and disseminate material, whereas the question before the court was really whether Google has a journalistic purpose. So essentially, CBC's submissions were more relevant to that other question that wasn't before the court. And then as far as the charter argument, because the reference wasn't a charter application, or there was no charter application that was part of the reference, and it was only basically questions of how to interpret the statute, the court ended up essentially saying that the Supreme Court's established that the charter can only be used to resolve a genuine ambiguity in interpreting the statute, and the court found there was none here. So, which isn't to say that there won't be charter arguments that will be appearing before we see any kind of a right to delisting affirmed by the courts, but for at least the purpose of the reference, it wasn't felt to be relevant here.
Yeah. Okay. Now that's a perfect segue really to where I wanted to sort of bring this together, which is, we've now got the federal court dismissing Google's arguments that obviously sought to exclude search results from the scope of PEPIDA. And while that I think is useful in terms of providing greater certainty on this right to be forgotten issue in the context of Canadian law, it obviously doesn't address many other issues, as the court itself it notes. So it doesn't address remaining questions such as the outcome of the complaint itself, doesn't address the power of the commissioner to recommend de-indexing, nor, as you just suggested, the constitutionality of PEPIDA. So why don't we start with a sort of basic question? What comes next in your view? We've got certainty on some aspects of this, but there is a lot that remains in many ways unanswered given where Canadian law currently sits.
Yeah, so in the normal course, if this decision were to stand, what I would expect is that, as the judge said, the complaint will essentially be sent back to the privacy commissioner, who will have to resolve essentially all of the other issues. So basically, we are arguing that there is a right to privacy, search engine privacy delisting that is already part of PEPIDA. That's essentially essentially flows from the rights that are in there. So they'll have to decide whether that's true, and then they'll also have to do some kind of balancing exercise with the Charter of Rights and Freedoms, which we've made arguments about in our complaint to show how we think it's what we think basically there is an infringement of free expression here, but that it's quite easily justified by the first article of the Charter. And once that, however, as I'm sure you know, once that's resolved, even if the privacy commissioner is to decide in our favor, it only has recommendation powers. So most likely, I would expect that we'll find ourselves back before federal court again, trying to get some kind of more binding order. And then to add to that, of course, maybe I should have stated this first, but it's always, or at least it's still quite possible that Google could appeal this existing reference to the Federal Court of Appeal and try to make further arguments. We don't know yet whether that'll happen, but presumably I would expect that to delay to delay the processing of the underlying complaint, although it's hard to necessarily say. Definitely from the perspective of my client, this decision, or we're sitting now about, I think, 4 years after the complaint initially being filed. And so the possibility of, I'm not sure if this would go to the Supreme Court, but the possibility at least of going to the Supreme Court twice before getting a final answer makes it look like a bit of a slog, but we're going to do what we can to get there.
Yeah, no, it sounds like this is the sort of thing that can play out really in some ways for many, many more years, that this isn't even necessarily the halfway point if you think about all the various elements that may lie ahead. So I guess that begs the last question, concluding with this, that you've been at it for 4 years already. Is, what's your view as to whether or not PEPIDA is well suited to deal with this? So there have certainly been some suggestions that this is an attempt really to shoehorn in this provision within PEPIDA, and that we would be better off with a more explicit provision as part of some privacy reform that would sort of more clearly address the issue. I don't know that that removes the likelihood of litigation, but at least provides a bit more certainty. Where do you stand? Is this something that you think you can and well, you have little choice at this stage, continue to work with, or should this issue really be dealt with more aggressively within the realm of privacy reform itself?
So it's a good question. I hope I basically only ever heard anyone who expects or would like this search engine privacy delisting remedy to exist. I've only really heard people say at least that it should, or that legislative reform would be beneficial, or sometimes people even say that it's necessary, which obviously I don't agree with on the basis of having filed this complaint. And I don't think I'm just being provocative, but I think I take a bit of the opposite view. And so, of course, in the abstract, a well-crafted legislative framework would, of course, be better, especially in reducing uncertainty and, with the long, perhaps decade-long time frame we're looking at around this case. I'd be the first to be happy to have it resolved much more quickly and much better. But I'm also conscious about the reality that we're in right now. So you've talked about there's this new legislative bill that may replace PEPIDA that's before Parliament, but seems to have stalled. So it seems like in practice things might not be going very far. But then even if it was to reboot and get going again, it doesn't actually, the bill as it stands now doesn't answer any of those questions. I mean, we could always try to push for amendments in it, but as far as it stands now, it doesn't explicitly recognize, nor does it at all explicitly say that this remedy couldn't exist. So we're stuck a bit in the same place, and that even if we were to achieve, getting some more explicit language in there, the pitfall there is, I think, falling a bit into the situation that Quebec is in with the new privacy legislation that's before the National Assembly there, which I think thankfully does include a certain right to search engine privacy delisting. And I won't go into the details, but I have a variety of concerns about the way it's been drafted. So there's always a risk of being careful, or being careful what you wish for. And so my perspective is that actually although it's not one that many other people favor, that the European experience worked pretty well, where the courts, there was no enshrined explicit right to private search engine privacy delisting when Google Spain happened. The courts recognized it out of the existing legal principles that are basically the same legal principles we have in Canada under PEPIDA. And then things developed to the point where it became recognized, and then it was codified in the law, and things have continued to move forward there. So from my perspective, in practice, it actually might be better to take that European approach, at least as far as, I wouldn't necessarily copy and paste the entire substance of search engine privacy delisting law in Europe to Canada, but I think the process they went through is one that's workable.
Yeah, no, I mean, it's an interesting perspective to take. In many ways, Europe is serving as a model quite clearly across a number of issues, at least from a government perspective on some of these things. Although one of the things that is striking is that it seems that at times we spend less time grappling with the Canadian situation. There's a desire to say, hey, let's just use this model. It's certainly what we saw in C10. But at least this is one where I think there's even certainly more time spent, and some of the issues certainly do cross over between the two jurisdictions.
Definitely.
Yeah. Okay. Mark, it's an interesting issue, and it's one where you've been really at the front lines. I appreciate you taking the time both to come in and talk a bit about it and give us a sense of what may lie ahead. So, thank you so much for joining me on the podcast.
Thanks again for having me.
That's the Law Bytes podcast for this week. If you have comments, suggestions, or other feedback, write to lawbytes@pobox.com. Follow the podcast on Twitter @LawBytesPod or Michael Geist @mgeist. You can download the latest episodes from my website at michaelgeist.ca or subscribe via RSS at Apple Podcast, Google, or Spotify. The Law Bytes podcast is produced by Gerardo Lebron Laboy. Music by the Laboy brothers, Gerardo and Jose Lebron Laboy. Credit information for the clips featured in this podcast can be found in the show notes for this episode at michaelgeist.ca. I'm Michael Geist. Thanks for listening, and see you next time.